Okay, good morning. This is going to be the final session for this morning before lunch. So we already have several session and panel discussion which are all very interesting. But in this session we have two very brilliant, outstanding scholars. One from University of Hong Kong and the other one is from National University of Singapore. The paper titled Piercing Corporate Veil Under China's New Company Law will be presented by Professor Pangyue Cheng from the University of Hong Kong, and the commentator will be Kenneth Khoo from National University of Singapore. Okay, so I will hand over the floor to our presenters.
Yeah. Hi everyone, I'm Pangyue Cheng. I'm the Global Academic Fellow from the University of Hong Kong. It's truly an honor to be here and to share my research with all of you. This is a wonderful platform for me to learn from your comments and suggestions, and generally appreciate this opportunity. Today, I'm going to share my research on the new PRC company law, focusing on judicial trends in corporate veil piercing in China, especially horizontal veil piercing between sibling companies. So let's just make it concisely so that we can have more time for questions and comments. Let's start with some background. In common law jurisdictions, veil piercing is considered an exceptional remedy. A well-known example is Prest versus Petrodel Resources, where the UK Supreme Court held that the veil should only be pierced when a company is being used as a facade to avoid legal obligations. Empirical studies have shown that veil piercing rates in common law jurisdictions have been gradually declining. For example, the piercing rate in the US dropped from 40% to 35%, and in Australia from 38% to 36%. I haven't found recent data for the UK, but I assume the rate still remains low. Now turning to China, the corporate veil piercing doctrine was codified in the PRC company law in 2005. In the most recent revision in 2023, a new provision was added that explicitly allows horizontal veil piercing, that is among sibling companies and the same shareholders control. And here's a current Article 23 of the PRC company law. It has three parts. The general rule: if a shareholder abuses the company's independent legal personality or limited liability to evade debts and causes serious harm to creditors, they are jointly liable. And the second, the new addition: if a shareholder controls multiple companies and abuses their independent legal personalities, causing damage, the companies are jointly liable. And then it have another special rule, the rule for one-person company. If the shareholder cannot prove that the company assets are independent, they may be jointly liable. So studies have found that China's piercing rate is much higher than in common law jurisdictions. According to Professor Huang, his research showed that it's over 63%. And Professor Horst and others, they also found that they extended the data set by 2 years, and they found an even higher rate, about 72%. So why is it so high? The Professor Huang offered two explanations. He thought that the lower levels of corporate law knowledge, especially in economically less developed regions. And the second thing is about a lack of understanding of key legal concepts like limited liability among judges, especially in lower level courts where piercing rates are found much higher than the higher level courts. However, another studies, they updated the research, they challenged the previous explanations, and in recent cases, the data shows no significant difference between developed and less developed regions, and a detailed review of legal reasoning suggests that judges do understand the corporate law concepts. The issue, according to Horace study, may lie with shareholders, not treating companies as separate legal entities and with vague legal provisions that gave judges too much discretion. Building on these findings, I wanted to test whether the 2023 codification of horizontal veil piercing actually changed how courts handle these cases and whether the previous explanations still hold up. So although the law didn't regulate horizontal piercing before 2023, the Supreme Court had actually already published a guiding case in 2011 involving 3 sibling companies. The court found commingling of personnel, business activities, and finances, including like the shared staff, similar business operations, and even a common bank account among the 3 sibling companies. So based on this, the court held that all the 3 companies were jointly liable. So even without a statutory rule, courts already have the guidance from the Supreme Court. But what happened after the law was codified? Let's just move forward. My research shows that the piercing rate in sibling company cases rose from about 40% to over 53% after the 2023 revision. At the first instance level, the increase was even more dramatic. You can see here, from just 18% to over 50%. In contrast, appellate and retrial courts maintained roughly the same rate, around 50%. So looking at the legal reasoning, before 2023, courts typically required plaintiffs to prove all 3 types of commingling: personnel, business, and finance, and often applied a serious harm threshold, which means that the court required the plaintiff to prove not only the commingling of the 3 features, but also they need the harm should be very serious. So after the revision, courts became more flexible. In many cases, the plaintiff can just prove 1 or 2 types of commingling. This was enough. And the serious harm requirement was also applied less frequently. So does this mean that statutory changes do influence piercing rates? And my findings suggest that yes. This implies that explanations based on vague laws or shareholder behavior are not the whole story. Instead, I suggest that China's high piercing rate can be better explained by some systemic differences between common law and civil law. So the first is about the judicial discretion. In China, veil piercing is codified in the company law, giving judges explicitly authority to apply it. In contrast, common law judges are more restricted by precedent and therefore more cautious about piercing corporate veil. And about legal reasoning, Chinese courts often view veil piercing as a tool to protect the creditors, especially given China's rapid economic development and frequent corporate misconduct. In contrast, the common law courts treat it as an exceptional remedy. And the third thing is about the policy orientation. Chinese judges operate in a system closely aligned with national policy goals, including, for example, creditor protection and financial stability. So by contrast, common law system may emphasize more about judicial independence. This policy alignment can lead to more mechanical application of veil piercing wherever legal conditions are met. So based on this, I offer 3 suggestions to help ensure more consistent and cautious application of veil piercing in China. The first is about issue detailed judicial guidelines. For example, clarify whether serious harm to creditors could be a decisive factor, and providing guidance, guiding cases not only for when veil piercing is applied, but also when it is not applied, when it is denied by the court. And the second thing is about clarifying the adventory threshold. Courts should apply veil piercing only when there is clear and compelling evidence, and also improving transparency in the courts. Judges may be encouraged to clearly document their factual findings and reasoning to enhance consistency across courts. So that's all for me today. Thank you for listening. I look forward to your comments and questions.
Okay. Now let's welcome our commentator, Kenneth.
So thank you very much, Dan, and all the organizers who are very kind to invite me as a commentator. This is particularly useful for me because I'm writing on the topic right now. So I'm Assistant Professor of Law at NUS, and today I'll be commenting on Pangyue's paper. Okay? So I'm going to start with the positives. So I thought that this was an excellent research question. Okay? In part, one reason why I thought it was an excellent research question is because I thought that the author basically pointed out this so-called anomaly associated with the very high veil piercing rates in China, right? And the author basically suggests that this challenges the assumption that the high veil piercing rate stems from judicial misinterpretation and provides some comparative analysis and suggests some legal reforms. Okay? In general, I thought that the paper was well organized, clearly written, and also provides a novel empirical contribution. Now, I'm going to talk about some criticisms or areas of improvement for the rest of time that I have, because I think that's where I think my value comes in as commentator. So first, I think we have to think about what veil piercing even means, okay? So I'm going to be very conceptual here, and this is the way that I teach my own students in terms of how we relate veil piercing to asset partitioning. So veil piercing generally refers to a doctrine that involves the violation of either one of 2 things. First, we can think of this as a violation of limited liability, or what Huntsman and Krugman call owner shielding, right? This is when we are disregarding the company's separate legal personality insofar as a claim against the shareholders' assets are concerned, right? We are foreclosing company creditors from making claims against shareholder assets. Now, that's not the case for entity shielding, or what Huntsman and Krugman call affirmative asset partitioning, where a shareholder's creditors are foreclosed from making claims against the company's assets, okay? Now, this is absolutely crucial, and the reason why this is absolutely crucial is because it is reflected in the doctrine, okay? And so when we look at the law, we will see that there's this distinction between 1 and 2, even though these are conceptual or theoretical concepts from Huntsman and Krugman, right? So let's look at Hurstwood and what it says about veil piercing. So Hurstwood, if I'm not wrong, it's a recent UKSC case, says the following: we are not ourselves convinced that there is any real scope for applying such a principle in the opposite direction to hold a person who owns or controls a company liable for breach of an obligation which has only been undertaken by the company itself. There's very little room for reliance on the evasion principle to impose upon the controller of a company a fresh liability as distinct from its controller. Now, what does this mean? It basically means that the door to claims against limited liability are shut. Okay, so exceptions to limited liability are basically very difficult to plead in the UK after Herswood and after Press. And this is something that I tell all my students, okay? And because of this, this makes Cheng's contribution very special in the sense that the entire rationale behind China's corporate veil piercing regime seems to provide a very stark contrast to the UK, where this kind of reasoning is not permitted at all, right? So I think the author might want to raise this paper in the introduction itself, so as to raise this contrast, right? To raise this very stark contrast and to appeal to the reader, oh my gosh, this is, there's such a huge difference between UK law, which Singapore also adopts, and the position in, okay, not really, right? Singapore law has a little bit of differences with Herswood, but this is the strict position in UK law, which scholars like me love, versus the kind of expansion in China, which is very interesting in and of itself. Okay, so basically, I have this diagram which I like to teach students insofar as asset partitioning is concerned. You basically have a series of rules that prevent company creditors from having claims over shareholder assets. That's limited liability, and then you have rules that preclude companies, shareholder creditors from making a claim over company assets. That is what we call entity shielding, right? It shields the assets of the entity from shareholder creditor claims. Now, of course, you have all these rules that prevent unilateral withdrawal of capital from the company. These are known in the anatomy of corporate law as the rules on liquidation protection. I'm very interested in these rules as well. That forms the complete picture, right? You have all these rules, rules of law that basically shield the company's assets from claims. What this in fact provides for is a subordination regime, right? It provides a subordination regime where certain claims are prioritized over others. And I think that's the beauty of corporate law, right? Because the separate legal personality is actually an extension of what we like to think of as subordination regimes or priority rules in insolvency. So this links back to Aurelio's talk earlier, where we can see this nice little connection, okay? All right, so this conceptual distinction is relevant to the author's The Way Forward, i.e. the legal reform section, because I think that while most of the reasons in the article are associated with legal certainty, that's certainly fine, but there are much more first-order fundamental costs and benefits associated with any veil-piercing regime. Okay, again, to re-emphasize, a veil-piercing regime subverts a subordination regime which is associated with incentives to invest. Okay, so because of that, having a very strong veil-piercing regime may actually benefit creditors. This is why I like formalism. So I'm a very strong proponent of cases like Foss and Harbottle. I absolutely love the rigid corporate form, no exceptions to veil piercing, very, very strict rule, because I think that it has real benefits, okay? It lowers the cost of capital through various mechanisms such as capital lock-in, long-term investments, so on and so forth. Now, of course, there are certainly costs associated with this, and the main one is controller opportunism, which is exactly what the Chinese regime is trying to address, right? So I think this fundamental reason is of first-order importance, and I think the authors should address this in the paper. Now, the mechanisms are also really interesting because while it is certainly true that the veil piercing rate is higher than in China compared to the UK and US, in the UK, the doctrinal scholars would always say that, well, the regime is narrow precisely because of the private law regime, right? So the private law regime, if you read the cases like Press and Petrodel, provides a robust response to the lack of expansiveness of veil piercing in the United Kingdom. Now, one classic example is the tort setting, where an independent duty of care can be imposed on a parent company where the original duty claim was between the subsidiary and the top victim, right? So you just extend a secondary or collateral duty of care to the parent company. And there are many other mechanisms, constructive trust, blah, 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 okay, agency, so on and so forth. Now, the author needs to address in a rigorous setting, why is it that the mechanism of veil piercing, which is a rule that disregards the separate personality of the company, is a better mechanism than that of private law, right? It's not very clear to me that's the case. For someone like me who likes a very constrained veil piercing doctrine, private law is actually the superior mechanism, right? I like private law as a way to get around these problems. As some of you would know, I'm also a shareholderist, so I like labor law, I like environmental law to address all these problems. And then, yeah, I'm a formalist in that way, okay? Yes, nothing to be ashamed of. So if private law mechanisms, the interesting point is, if private law mechanisms are inadequate, well, this is one response, right? This is one response to why we have very high veil piercing rates in China. Okay, I'm going to skip past this point because it's kind of minor. I think that judicial discretion per se doesn't tell us anything about what veil piercing, what the rate of veil piercing should be, because it depends on how whether judges are liberal or conservative in their initial approach before the reforms, right? So if they're very liberal in veil piercing, then of course you're not going to see a lot of change. But if they're very conservative in that they don't want to pierce the veil before the reforms kicked in, then you would of course see a difference, right? Again, this is just about what is their starting position. In the United Kingdom, the starting position tends to be more conservative, so judges don't like to pierce the veil unless they absolutely have to, right? This is seen also in the doctrine. Okay, now let's turn to the empirical analysis, which this is my bread, well, what I do for most of my work. Several good points, which is you have a very nice sample, the author has a very nice sample size of about 4,440 cases in, 4.4K cases in 2020. However, the author focuses a lot on subsets of the sample, which are very small, which leads me to doubt to be rather doubtful of the inferences from these changes. For example, a change from 2 to 0 could be just pure statistical noise or randomness, right? It's not necessarily the case that this is due to the change in the law. What I would suggest is to have a looser criteria with regard to sibling companies. So there are lots of, just tell the AI, with the rise of AI, you can tell the AI to use natural language processing. You have all these cases. Okay, tell it to look for a broader interpretation of what a sibling company is. And I think that will give you a lot more sample power. Now, the next point is a classic kind of law and econ claim, because I'm a law and econ scholar. So when writing these papers, one has to be very, very careful about making causal claims, because causal inference is kind of the key methodology in modern econ and finance. Causal claims need to be backed up by tight data and tight mechanisms. Okay, I'm going to talk about what that means shortly. So first, after the change in the law, there could be many other confounding factors that could have led to the increase in veil piercing cases, right? We don't know what those factors are, but this could involve things like firm characteristics, litigant characteristics. When we talk about litigant characteristics, we're talking about both defendant and plaintiff characteristics, court characteristics, all sorts of things could basically lead to a change in the rate of veil piercing and not the law itself, right? So a lot of things are going on, and it's not necessarily the law that has, induced this change. Now, the worst thing is that if any one of these characteristics were to be the key driver for the change in the number of cases that are observed, then the causal inference is no longer valid, right? And a whole lot of papers which try to include these controls are summarily are just rejected by econ journals because the standard is very high, right? You have to show that there's only one mechanism that leads to this change and that there's no other plausible mechanism that led to the change. So the standard of proof is very high. The other problem with using case counts and success rates, the author uses case counts, in law and econ is that the change to the law can result in a change to settlement rates. So this is a well-known problem. If you observe that the cases that are settled, you can use a selection bias model to correct for this, but then the problem is that you don't here, right? So again, I would encourage the author to clamp down on causal claims. So the way to do it would be that, although explicitly stated, right, although a causal claim is not advanced here, these are some descriptive statistics that suggest that X, Y, Z. Okay, I think that the main contribution in the paper should have come from the comparative analysis component. Here I had a lot of questions. In fact, when I was reading it, I thought that this was the main contribution of the paper, to the literature. So one suggestion would be, in common law jurisdictions, statutes often allow courts to disregard the veil. This is so-called statutory veil piercing, even though I don't think it's entirely accurate. So how is China's position different from these examples? We already went through private law mechanisms. The other interesting point is concerns creditors, right? So creditors will self-adjust their behavior in response to the veil piercing regime. What this means is that if the veil piercing regime is very tight or very loose, well, it could be very strict or very relaxed, then creditors are just going to respond rationally, right? So how do they respond? Well, they respond by pricing it in. This is classic Easterbrook and Fischel, right? They're going to respond by adjusting their interest rates, okay? And then the question would be the irrelevance principle, right? Why does the veil piercing regime even matter in the first place? So one response to this could be, well, I have evidence that creditors don't actually adjust, okay? Or I have evidence that a large bunch of creditors are non-adjusting, and this would be a nice response to these kinds of questions. The last point I wanted to make was that in common law jurisdictions, approach taken as to whether the company is a separate legal person can be very formalistic. However, the thing is that in common law jurisdictions, you will see that this kind of formalistic approach is not taken in other areas of law, such as competition and tax law. In fact, if you read the cases concerning veil piercing in let's say in common law jurisdictions, you will see that the judges explicitly refer to competition law and tax law as exceptions to how they treat the company as a separate legal person, right? So one question I had would be, well, why is this the case, right? So surely it can't be that even in common law jurisdictions, you have this disparate approach, but then in China, you suddenly have a reversal of the position without considering other areas of the law. And this in turn raises a more interesting question as to why. Why is it that in China, a lot of emphasis is placed on the corporate law regime rather than other areas of law? So I think that's a fascinating question. Okay, overall great paper. I hope that these comments were helpful.
Thank you for the excellent comment from Ken. And so Professor Chen, do you have any response?
Yeah, thank you for Professor Khoo. It's a very, very, very good, useful, and good comments for my paper. It's a very early stage of my draft, and I'm continue to check and collect the cases that happen in China. You know, the PRC company law has just been revised in 2023, but it actually took effect on July 1st, 2024. So the cases now I'm still collecting, and the reason that I focus on the veil piercing among simpling companies is that it's the newly changed in PRC company law. So I found that a lot of scholars that are trying to argue that the high piercing rate is because of the vagueness of statutory, but the PRC company law, they are trying to clarify the circumstances of piercing the corporate law among sibling companies. So I want to know what happened after this codification, whether this codification contributed to higher or lower piercing rate among sibling companies. So I'm trying to provide another explanation of this one, and I know that there are a lot of factors may impact the high piercing rate in China, but I'm trying to figure out it, and if it is, as the the previous slides I showed that in the empirical research, it seems like the judge did actually more willing to pierce the corporate view in China after the 2023 revision. So I would like to provide more suggestions because when judges found they are authorized by the PRC company law, they can pierce the corporate view among simply companies, then they are more willing to do that. So I want to provide suggestions to respond to such kind of circumstances and trying to provide that you cannot just authorize them, you can pierce your corporate view, but you need also provide some guiding cases that in what circumstances they cannot pierce the corporate view. So yeah, that's my response, but thank you for your comments, and I will continue to work on this draft and improve more, provide more data, more cases, and improve the quality of this draft. Thank you.
Okay, thank you very much. So now floor is open. So we have two, and Professor Zhou.
Thank you. Sorry, I missed maybe the first part of your presentation, but in your empirical part, do you know who are those plaintiffs? What kind of creditors? Are they banks, financial institutions dominantly, or trade creditors, or what type of creditors? The reason I'm asking this is it's my observation that overall the Chinese company law is quite pro-creditor compared to probably U.S., UK laws at least. And I tend to see the veil piercing rule is part of that kind of package. It's the pro sort of creditor. And I speculate the one reason that law was drafted in that way probably is because of the very strong influence of the financial institutions, especially the state-owned banks behind the scene. So that's my first question. Second, also empirically, I don't know whether you see there is a variation in terms of the enforcement of the veil-piercing rules across the country in different places. The reason why I'm asking this is based on some very early, of course, old sort of empirical evidence in U.S. and both in U.S. and in China. Maybe you know Professor Robin Huang. He had an excellent paper in China. They didn't drive to this conclusion, but it's my observation from both these papers that it seems that piercing veils are more likely in those economically less developed places. I actually observed this, both in the U.S., if you look at New York, for instance, Delaware, and certain more sort of advanced economic California, less likely pierced, but in some more sort of remote places. And China seems to me has similar pattern. But of course, it's just, again, it's very random sort of anecdotal observation. I don't know whether, given your data, will it be possible to have some, better sort of empirical support or, so refute of this type of possibility. Thank you.
Thank you, Professor Zhao. Actually, I do, see what happened in China, where it is happened, but I know that Professor Robin Huang wrote that article. He found out that in less developed, economically developed region, it may have hair piercing veil rate in that region. But after that, after 2 years later, another the Professor Horst and others, they published a new study to say that they didn't find no significant differences between the less developed region and developed region. So I also conducted such kind of research, and I found that I didn't find any, the significant changes between highly well-developed region and the less developed region. But I need to continue see the data and check the data in the future, because it may be due to too few cases, but it may be also other reasons. As for the reasons for the creditors of these sibling companies. In my research, I found that there are a lot of cases related to the debt, which means that the creditor, they lend money to the company, and one company found that I cannot pay that debt, and the court pierces the view of other sibling companies to require these sibling companies to pay the debt to pay the money to the creditor. So that's the most prevalent reason in China currently. So I'm still continuing, to check all the data and the cases. Yeah, correct.
Yeah, I'm Nathaniel from Universitas Indonesia. So my kind of query is that how kind of the field piercing works in the state-owned enterprises, because if you kind of have creditors and there's for example, a joint ventures or a business together in an SOE and maybe a foreign party or another third party, then if something happens, would you able to go directly to the state? Is it like, and how that works with the current kind of regulations in the new law in terms of how you kind of make sure that it's kind of the field piercing, is that the state will protect itself against any field piercing versus third parties? The reason I've asked this is Indonesia, we have a new development on state-owned enterprise law, which now clearly stated that the assets of the state-owned enterprise are separate from the state, but it remains to be tested whether if, for example, like the impact would be if someone corrupted like the board of directors in the state-owned enterprises, it's now stated it should not be a state loss, it's just the company loss. And this is one thing I'm kind of curious whether the field piercing work that way as well in China in terms of if you have a state-owned enterprises and have loss, would it be a state loss or not? Because it works both ways in terms of whether the loss state goes to the company or the company can also go to the state. Thank you very much.
Thank you for your question. So in China, in my data set, I found that there's quite a few SOE evolved in piercing corporate view rate among sibling companies. And as for the sibling companies, in China, the practice is that when those sibling companies is under the control of the same shareholder, then and one sibling company, this abuse its limited liability, and the other sibling companies may be pierced their view for claiming that of others. So I would say in SOE, I didn't observe it was pierced to the controlling shareholder. So it's just among the sibling companies and the shareholder. And I also found it quite a few cases that the court both pierced the view of controlling shareholder and pierced the view of sibling companies. It's just at the second level of they pierced the view among sibling companies.
I only have one question, which is also a very short comment, is that, in fact, I'm a little concerned about how your empirical study showed the real change in China, because there is actually an interference fact that is not considered in your empirical study, which is that the judicial openness in China has been undergone a great change, and nowadays the judicial decisions are less and less made open. So so judges may choose not to disclose very controversial and unclear decisions, but only choose to upload and make public all these very clear and simple and more straightforward application of law. So that might be a reason or a contribution factor to your observation. So this is, in this case, so because the change of this openness of judicial decisions happen at the same time of the rule change. So I think the conclusion might be more carefully examined. Thank you.
Okay, before you answer, this session will end roughly 3-4 minutes later. So I would like to, you know, one thing is that, you know, piercing the copper veil is actually two principles. One is limited liability principle, supposed to be the general principle. And then piercing the copper veil, whether this should be, you know, exceptional. So when, you know, many continental countries trying to codify the common law principles into the continental statute, sometimes we are trying to codify is to simplify it. So maybe there's a lot of content, but we only use maybe one provision and to cover everything. So this would, you know, become one result is that looks like the copper veil in common law jurisdictions are thicker and is thinner in continental, so it becomes easier to be pierced. So I don't know whether you can also tell us, if you have time, see how when we codify and we have think of many kind of things, including vertical, horizontal, you know, traditional piercing copper veil, reverse piercing copper veil, and so on. So whether when the statute was amended, you know, they have thought of many things.
Thank you. Thank you. First of all, let me answer Professor Zhou's question. It also what I concerned about my research. You know, in China's online judgment website is trying to you know, license disclose the cases that published by courts, and courts actually they may select the case would have very clear evidence and very clear statutory rules, and they will disclose that. That's why in my research I'm trying to look at the reasoning, the legal reasoning to conduct the not quantitative, it's qualitative analysis of case to understand how judges, you know, they understanding the piercing corporate view and how they adopt such kind of rule to make their decision. I think I still need to continue to observe the things because we don't know what happened in this year and in the future. So we need to check whether the court, the judge actually they disclosed all, not disclosed all, they trying to disclose more and more cases about veil piercing rate. But one thing I found that it's, although the court declined their disclose about such kind of cases, but the cases not within 1 year, because it took effect July 1st and until today, it's not, it's still within 1 year, but the case number is increased a lot. So it just show the trend that after 2023 revision, the court that try to accept more cases of stimpling companies. So as for your question, yes, I know that there have some, you know, when you transplant doctrine from common law to civil law countries, then sometimes we just transplant some general and simple provisions from others. Just take the veil piercing as an example. It authorized courts can pierce the corporate veil when shareholder abuse their ability, their power to to abuse the limited liability of company. So what my suggestion is that we need not only to see that this is a general rule that you can pierce a corporate veil, but we also need to emphasize that this is an exception. This is an exception for, exception of piercing corporate view, and also we need to provide some guiding cases of pierce and not pierce. So it's trying to let the judge, let the court know better about this doctrine. Yeah, thank you.
Okay, thank you, Professor Chen and Professor Kenneth for excellent presentation and comments. So this will conclude our session. Let's give our hands to thank our presenters and commentators.